My name is Cynthia Hassan. I am a child protection screener. So as a screener, I am to child protection what a 911 operator is to law enforcement. So anytime a person is concerned about the welfare of a child, they call us, they make a report. Today's training, I'm going to cover how the state of Minnesota defines child abuse and your role as a mandated reporter. If at any time you have questions, feel free to ask. Otherwise, you can call us at any time. We answer the phone 24 hours a day, 7 days a week. And anytime you have a question, we really encourage people to call and ask those questions. How are we advancing the slides?
They're up here, so you can just raise your hand.
All right, let's hit it then. So there's the statute. Some of you may or may not know that in 2014, Governor Mark Dayton commissioned a Child Protection Task Force to completely overhaul the whole child protection system in the state of Minnesota. That task force was put together after yet another child homicide by their caregiver in their home after repeated reports to child protection where obviously child protection failed to keep that child safe. So the task force is made up of child protection, medical people, parents, community leaders, religious leaders, therapists, and a wide variety of other interested parties. After the completion of the task force, they submitted 93 different recommendations that were put into place in 2016. There were many changes in child protection, not the least of which is that our caseloads expanded considerably. With that said, you can go ahead and advance. Minnesota is somewhat unique in that in the state of Minnesota, child protection is responsible for investigating allegations of abuse that occur within the family system only. So if a child is making a statement about being abused by someone outside of the family system, not a household member, not a family member, law enforcement has jurisdiction over those reports only. We don't have any jurisdiction. You don't need to commit that to memory in terms of who do I make a report to. When in doubt, just call us. If we don't have jurisdiction, we're going to get that report to the right person. In some other states, child protection is involved in every allegation of abuse to a minor. But Minnesota is unique. The other thing is that the state of Minnesota has 87 different counties. Ramsey County happens to be the most diverse, as is reflected in this room. So what that means is that our practice in child protection, while we're still following the law, we have to become familiar with the practices of our community members so that when we are meeting up with these families due to an allegation of abuse that does rise to the level of child protection becoming involved, we want to familiarize ourselves with those particular practices. What's the goal for those caregivers? And then try to bridge that with informing parents about what the rules and regulations and laws are so that they can make informed decisions and avoid coming in contact with child protection at some point in the future. You can go ahead. I kind of talked about a little of this. You can go ahead. So the state law is there and protects everybody who lives in the state. My husband happens to be from the Middle East. My mother-in-law married my father-in-law when she was 14 and he was 21. If that happened here, it would be considered statutory rape, and my father-in-law could have been charged and convicted with statutory rape, and he might have to register as a predatory offender. With those kind of serious consequences, it's really important that we're informing the community about that particular law, but also a lot of other laws with regard to what's considered child abuse. So with that said, go ahead. There are three kinds of reporters that we come in contact with in child protection. The most obvious is yourselves as mandated reporters. Then there's voluntary reporters. So those are people who are not required by their job or profession or licensure to report abuse, whether it's the maltreatment of an adult, a vulnerable adult, or a child. And then there's reporters who are anonymous. They're also not required by licensure or position or job to make reports. They're just choosing to do so. Might be a family member, might be a neighbor, just concerned citizen calling child protection to make a report. When making reports, it's really important to remember we have to know some basic information. We have to know who, what, where, and when. So kids coming from all over the world, right, living here, families from all over the world living here. We have different ways of defining and describing parts of our body. We have different ways of describing and defining different behaviors and actions and so on. So it's really important for us to make sure that we're understanding what the child is saying and that we're not making assumptions, we're not connecting the dots. Here's an example. Child shows up at school, they have a scratch under their eye. What happened to your eye? My mom hit me. For whatever reason, I asked the caller to ask more questions. Well, what was going on when your mom hit you? Well, the story was the children were in the back seat of the car and they were fighting and hurting each other, and mom puts her hand back while she's driving to separate them. It was not an act of discipline. That report got screened out. Another example, a child comes to school and they have linear marks on the back of their legs. What happened? My mom was swatting my butt with a belt and I wiggled around and it left a mark. The mark is the tipping point. It's not the object. It's not the act of discipline, because physical discipline is legal in the state of Minnesota. If a parent chooses to employ corporal punishment, physical discipline, that act in and of itself is not against the law. It's about what's the measurable negative outcome to the child as a result of that intentional act of discipline. And that doesn't mean to say that parents are intentionally trying to injure their children. That's not the assumption. The assumption is that act of discipline, and more often than not, if you use an object, it's only a matter of science. If you choose to pick up an object, chances are you're going to leave a mark. We'll get to more of that later. So for mandated reporters, go ahead. The law does require you to make a report, and it's very vague, and this is what it says. It says anytime you have a suspicion of abuse, you are required to make a report. You don't have to know if it's true or a lie. That's not your job to investigate the veracity of the report. That's what Child Protection's role is. We have a report form on our website. We don't require that you use our report form. If your organization has a report form, feel free to use that. The nice thing about our report form is that it really clues the writer into providing us with the information that's necessary for us to proceed. When we receive a written report in Child Protection, we have 24 hours to making screening decision. So when we get the report, we want to make sure that we have the identity of the people that you're reporting on. We know where they live. We have an idea about what happened and when it happened, and what was the negative outcome to the child as a result of it. I can't tell you how many times I get reports, and the reporter says, writes a report saying that this child reported that their dad repeatedly slapped them, took a belt and whooped them, and they were very upset, and so on and so forth, and then that's the end of the story. Okay, well, that story is a sad story, but I have no idea whether or not that child has any kind of mark or injury because they didn't follow through with, so what's the outcome as a result of what happened with that particular event of discipline. As mandated reporters, you do not have the luxury of remaining anonymous. In other words, when you call us, you have to identify yourself. When you fill out a report, you have to put your last name, your organization address, and so on. When we meet with families, we are not allowed to say, Cynthia from Park and Rec made a report that you did such and such to your child. That's not the conversation we have. When we meet with families, we're saying, we received a report that X, Y, and Z. Lots of times kids will go home and they'll say, a policeman came and talked to me today, or Child Protection came and talked to me today, and so parents will obviously know, well, you haven't gone anyplace but the rec center or the school, so obviously there was a report made there. But they're not going to get that information from Child Protection. Go ahead. After we make that screening decision within 24 hours, we'll also send you a letter, a disposition letter. However, if you want to know sooner, once that report that you submitted is screened, we'll tell you what the outcome is verbally as well. Because sometimes you're concerned, do I need to give this, maybe it's a 12 or 13-year-old who said, I want to know before anyone talks to my parents. And we're happy to try to coordinate that and make that work for that kid. Voluntary reporters, again, just concerned people, but they're willing to give their contact information in the event that the worker or sometimes the screener has more information about what they're reporting. And then the anonymous report is pretty self-explanatory. Go ahead. So for mandated reporters, the law says you have 24 hours to make a verbal report or call it into us, and you have 72 hours to complete a written report. We're asking you and believe it's best practice to call us right away. As soon as you are concerned about the welfare or safety of a child, we'd like you to call us right away, maybe even while you still have access to that child, in the event that we need to establish a safety plan. Or maybe we have some other question we'd like you to circle back. We don't want you to do our investigation for us, and we know that that can be sometimes uncomfortable about asking kids questions or circling back or whatever, and we'll help you with that. We're not going to make you do or ask you to do something that you're not willing to do or you don't agree with or whatever. So we're asking you to call us right away, and then we're also going to ask you to send in that report right away. But the law does technically give you that time period. So 24 hours for verbal, 72 for written. Go ahead. ICWA, the Indian Child Welfare Act, that's a federal law, and that requires all social service organizations, child protection, anytime there's a report made regarding an Indian child who's registered or eligible for registration, or one of their family members, we have to notify that tribe or tribes immediately. So overnights, weekends, whatever. So there's a question on our form that asks if this is an Indian child. It's really important that if you know that you're checking yes or no, because that impacts our work at our front door. Go ahead. Types of maltreatment. If you think about family investigations as felonies, and you think about family assessments as misdemeanors. So that's kind of the approach. And it really is a way to qualify the level of risk to the child, or the level of injury, or the level of harm, or it might be related to what state statute says about the kind of response. So the only difference between the two, other than the severity of the cases that are put into each of those tracks, is that for family assessments, so those are those less serious cases that I can give an analogy of, it's a misdemeanor, is we don't use that record for the purposes of employment. Here's an example. I have a third grader who's very mentally ill, has significant mental health issues, and is refusing to go to school and has refused to go to school for 2 months. It's taken a long time to get an assessment, get some therapy and maybe medication. So the school makes a report to Child Protection for educational neglect because my child has excessive unexcused absences from school. Child Protection becomes involved, and our job is to alleviate the barrier to that child returning to school. So that wasn't about a child who was physically harmed in any way, and even if it was a minor physical abuse case, there's no safety threat technically to that child. So for those cases, it can't be used to prevent a parent from either maintaining employment or from gaining employment in working with vulnerable communities. So that would include a vulnerable adult, or anyone who's under the age of 18 is considered obviously a minor, but that in and of itself, for the purposes of protection, means that they are vulnerable as well. Any questions about that? So in about the year 2000, the federal government developed this second track. It used to just be the family investigations. So we have 45 days to complete our assessment. At the end of that assessment period, we have to determine whether or not maltreatment occurred and who was responsible and whether or not ongoing services are needed. They developed that second track intentionally so that parents and families are not harmed by having those contacts with Child Protection held against them. So there's still a record of it, but it just can't be used for employment purposes. Okay? Go ahead. The kinds of reports we're investigating: physical abuse, sexual abuse, and neglect. Physical abuse, the most concrete, observable, measurable. You can go ahead. Because physical discipline is legal in the state of Minnesota, we obviously have to define it, because one person's beating, whooping, whatever might be a walk in the park to another kid, whereas in some families and communities, any kind of physical discipline is simply unacceptable. There are some states and some countries where any kind of physical discipline or corporal punishment is against the law. So here in the state of Minnesota, as I said, it's legal. So these are the ways that we try to break it down and define it. Remember, circling back, I mentioned the task force. So the state of Minnesota, every county, 87 different counties, uses a guide in determining whether or not a report meets our criteria, and they're called our screening guidelines. So we're referring to those guidelines all the time, every day. We're constantly in consultation with our peers, with our superiors, with the county attorney's office, and so on. So we're really not making hardly any decisions in isolation. So the obvious, anytime there's a marker injury that's a result of an intentional act of discipline. A kid, I've had reports where children will come to school and they'll have a burn on their face. What happened? My mom burned me with her cigarette. I'm going to want lots more details about that. Does that mean that she held the cigarette in your face and burned you with it? Or you were running around the house, your mom was smoking, and you ran into her cigarette. So they're not lying. They're telling their version, and we just have to make sure that we're understanding exactly what they're trying to convey. Go ahead. So physical abuse, the last one on the previous slide was threats to kill children. I don't know about anybody else in this room, but I raised 3 teenagers, and they're all alive, healthy adults now, but when they were teenagers, I felt like some of them had death wishes on some days. So with that said, unfortunately, parents continue to murder their children and kill their children. So when kids are talking about, my mom said she was going to kill me, I have to talk further and ask more questions. Was it my version of killing my children, or is it a serious threat to the child? So we really have to pay attention to those. Parents making those statements, it's called threatened physical abuse, and we respond to those cases and take them very seriously. Striking a child with a closed fist, whether or not there's a marker injury. Kicking, punching, throwing. So you're pushing your kid out the door, they fall down and you start kicking them. That could be reported to Child Protection with or without a marker injury. And this was really pushed, I think, from medical professionals, pediatricians, and other medical providers who were so concerned with the number of injuries that were not visible to the eye, but depending upon the age of the child, you're kicking, punching, throwing, and that could potentially be a life-threatening situation that, again, you can't observe that. It might be a broken rib that's perforated, an internal organ, or something like that. Aversive deprivation procedures, unreasonable interference with a child's breathing. I have been in child protection, as we said at the beginning, for 33 years, so I have a little bit of a dark humor. And so this is another area where we have to ask more questions. Kids will often say, my mom choked me, or my dad choked me, or somebody choked me. So we have to understand what that is. Does that mean I was wearing a hoodie and I started to run away and I got my collar grabbed to come back here? Or was I fighting and my mom was pushing me away and so her arm is on my neck? Or are they choking me? I need that kind of detail. And when talking too, keeping in mind to not be asking yes and no questions, because that really lends itself to suggestibility, because you're offering them an option. Did this happen or did that happen? As opposed to, can you show me? Can you tell me? Can you point to it? Can you draw a picture of it? We don't want anybody using anatomical dolls, nothing like that. But we really do want to try to understand the best we can so that we're not connecting the dots and making assumptions with families. Okay? Go ahead. So neglect, any questions about physical abuse? Okay. So neglect is really about what a parent or caregiver does or fails to do to meet the minimal needs of their children. And when we're talking about minimal needs, it's not my kids who used to call and say there's no food at home, that means we're out of chips and pop. If there's no food at home, that child might be failure to thrive. They might be underweight because they don't have access to an adequate amount of calories. Is food being withheld from them? Are they being punished and so they don't have access to food? We might ask questions such as, does the child appear to be overweight? If they say yes, sometimes I'll ask, what do the parents look like? Because some people are just, they're stick thin, their kids are stick thin as well. Or a child saying, they're hungry. Being hungry in and of itself doesn't necessarily mean you're going to get reported to child protection. We want to know, so do you have access to food? So there's no food at home, but I go to Grammy's house across the street and eat all the time. Or my mom brings home fast food, or whatever. So those breaking down those details when kids are, or you're noticing what you believe to be a deficit and possible neglect. So what am I talking about when I'm thinking about neglect? I'm thinking about food, clothing, shelter, supervision, medical care, dental care, and education, those kinds of things. So food, clothing, shelter, while a lot of families, unfortunately, that we're working with are food insecure, they're housing insecure, we do what we best, and you do your best in making sure that families have access to adequate resources. So with neglect reports, it's not just identifying that there's a need that needs to be addressed, it's not negotiable, and I'll give you an example in a minute. So it's identifying that the need or issue is non-negotiable, because without intervention, this is going to be the significant, measurable negative outcome to the kid as a result of it. That the parent's been notified that it's non-negotiable, that there's been some discussion about what's preventing the parent from doing X, Y, and Z. The parent says, let's say for instance a child has rotting teeth and it's very painful and they can only eat soft things now. So letting the parent know this needs attention. Without care, your child could get a very serious infection. It could have significant negative impact on their health and well-being. The parent says, I don't have insurance. You're giving them a referral or information about where to go for free dental care. The parent goes, problem solved, child protection never needs to become involved. The parent doesn't go, the child continues to suffer. You're making a report to child protection. You've identified the issue, you've ensured that the parent is aware of what the issue is, you've offered the resource that they've identified as a barrier for their child getting whatever they need to get. Here's an example. A family, let's see, it's a Southeast Asian family. They are at the park. Their 3-year-old falls off the slide, breaks their arm, compound fracture. Not neglect, they're there and stuff happens, right? They go to the hospital, the doctor says, well, it is broken, I'm gonna put a temporary cast on, but I have to do surgery and put pins in there and so on and so forth. And the family's like, wait a second. We have to go back and talk with the family, talk with our elders, our healers, shaman, whatever they choose. We would expect that the medical provider try to negotiate that with the family, and it would look something like this. Well, I have a 48-hour window. This is a surgeon talking. I have a 48-hour window before I can get in there and provide this child with the care that I believe is necessary. Because without me doing the surgery and so on and so on and so forth, the child's going to have chronic pain. They're going to have limited range in motion with their arms. So it's a permanent, significant bad outcome. So the surgeon offers this opportunity, the best of both worlds. The family comes back after the 48 hours, the child gets the surgery. They engaged in healing in the way that they preferred and so on, and yet the child did get the care that was absolutely necessary. If they don't do it, then the county attorney has to get involved and we have to get court orders to get the necessary medical care. Clothing, as long as clothing is occasionally laundered, it's appropriate for the weather, it protects children from the weather, that kind of thing. Covers up their private parts, we don't get involved with that. In the wintertime, they don't have access to warm clothes. Practically every school I've ever been in contact with has closets with winter clothing to keep kids safe because stuff gets wet, wrecked, dirty, so on and so forth, or Maybe they simply don't have access to what they need. When we're thinking about education, parents are responsible for their children's school attendance until they turn age 11. And I'll let you know why in a minute. So in the state of Minnesota, most people register their children for school at age 5, but the state law does not require you to register your child for school actually until age 7 or for first grade. So kindergarten is wonderful, and of course most people even send their kids to preschool too. So it's the school principal who determines whether or not an absence is excused or unexcused. It has to be that school administrator. So a kid could be missing 60 days worth of school, but if they've provided that administrator with legitimate reason for missing that much school, then it would never be referred to child protection. In the event that a child has 8 or more unexcused absences, what happens? In Ramsey County, we have a protocol to try to divert those cases so they can avoid coming to child protection. The county attorney's office, the school administrator, and the parents have a meeting to discuss what's the barrier to your child attending school. The biggest indicator to, now this just went bye-bye? Or did I turn it off? Okay, I did it. The biggest indicator to graduating in high school, anybody know what it is? Just show up. Just show up at school. So even if the kid is not really participating or engaging or whatever, just being there is such a huge indicator of their future success. So if that doesn't work, if they can't take care of that problem at that point with a meeting with the parent, the county attorney, and the school, then it gets referred to child protection. For the purposes of medical care, dental care, mental health services, unless it's deemed absolutely necessary, then we don't get involved. So generally we need some sort of a professional lens if we're talking about a medical condition. I'm not a medical professional, so a person could have asthma, and if the parent or the child doesn't want to cooperate with what's recommended by the doctor, we're not going to get involved in that unless someone tells me that their asthma is so significant that this is perhaps going to be life-threatening or have a huge negative impact on the child. Because some people have asthma and they just get colds more often, whereas other people have asthma and they can't breathe and they have to go to the hospital and so on and require emergency intervention. So if you are age 11 or older and you are not attending school regularly, you have excessive unexcused absences, those cases are referred to the county attorney's office, and you might get assigned a probation officer. You're considered truant. So that's a different response. When we're thinking about supervision, in Ramsey County and throughout the state of Minnesota, you have to be 8 years old to be left on your own. So if you're under age 8, you have to be supervised at all times. It's never okay to leave those children alone. Playing outside? Absolutely. So what does supervision look like? I know how I define it, but it could be defined much differently for other people and families and caregivers. So when I'm breaking down supervision, I'm talking about a child who's requiring supervision. Their caregiver has to be sober, alert, aware where the child is, able to respond in the event that the child needs help, and a responsible caregiver. So if you're not yet age 5, supervision to me means that I can physically reach you within seconds. So I'm at the playground with you. If you're 3 years old and I live on the 8th floor of our apartment building, looking out the window or the balcony or whatever occasionally is not supervision. So those kids need someone who's hand-on that would be able to offer some immediate aid. There's a family in my own neighborhood in Whitey-Whiteville, where I live, and it's unbelievable, the kids that are just running all over the place. The 3-year-old I keep bringing home from the pond, and oh, he got out again? Anyway, so if you're 5, 6, or 7, you can be alone for 2 to 3 hours at a time. We expect parents to use discretion. Is your 5, 6, or 7-year-old, are they comfortable being left unattended? Or no? then you can't leave them unattended if they don't feel safe or comfortable or whatever, but 2 to 3 hours at a time. In Ramsey County, we don't care if it's night or day. In some other counties, children that age, they'll say can only be during daylight hours. Those children can be unattended. So children 8, 9, 10, and 11, 8, 9, and 10, 2 to 3 hours at a time. Once you reach age 11, you're old enough to babysit, in other words, watch children younger than you, and you're old enough to be alone for up to 12 hours. So what does that mean? We expect that 11-year-old is capable and willing of babysitting children younger than them, and we expect that the parent of those younger children is using discretion with regard to the number of children being babysat and the ages. You can have a 14-year-old who's babysitting, but maybe they have some cognitive impairments and they have the decision-making ability of an 8-year-old. Obviously, that's not an appropriate caregiver. Neither is my brother-in-law getting out of Lino Lakes because he doesn't have any place to live and he has to register as a predatory offender. That's not an appropriate caregiver. We have no authority over said brother, but there's going to be a child abuse investigation for neglect for exposing your child to that kind of danger. Anybody who has that kind of registration for being a sexual predator, and we'll get to that in a little bit. So once you get to be age 16, you're considered the age of consent. So there are some adolescents and parents who make a decision that the 16-year-old can go live elsewhere. And that's the decision they make, and the 16-year-old is able and willing to either take care of themselves, or they're living someplace where the other people are willing and able to help take care of that youth. Otherwise, parents are responsible for their children until they turn 18. Circling back to the legal age of consent, we sometimes get involved in those cases of early marriages that I kind of touched on earlier when I was talking about culture. So if one person is under the age of 16 and the other party is 24 months or greater, that's considered statutory rape. And the older person can be charged and convicted of those offenses, and they may have to register as a predatory offender once they complete their sentence, if they're sentenced to a correctional facility. And that kind of label can follow you around for decades and sometimes a lifetime. And that can have a huge impact on your children. If you don't have children, it can have a huge impact on your family and other loved ones. With those types of cases, our response is dictated by state statute. We don't have any discretion in getting involved in those kinds of reports. So anytime a person who has to register as a predatory offender is living with or has children, automatically child protection has to become involved. So again, around the year late 1990s and early 2000, they greatly expanded how they classify people with felonies, particularly if they have convictions for felonies where they've harmed another person. So it used to be that child protection, we would only get referrals on cases where a person had a conviction for sexually assaulting a minor. Then child protection would become involved. Now the law has been enormously expanded, so anybody who has a status as a predatory offender, that also incorporates those offenders who have convictions for trafficking or kidnapping. Sometimes offenders can be convicted of kidnapping when they're involved in a domestic and they don't let the victim leave. You can be charged and convicted of kidnapping. Not like, I mean, obviously stranger kidnapping, but otherwise it's someone held against their will. So we have to vet, those cases a lot. I also go out to Lino Lakes and talk with offenders who have participated in their treatment program, their sexual offender treatment program, who are due to be released within the next year so that they know what to expect when they are released. If they have children, living with children, having access to kids, those kinds of things. There is a light at the end of the tunnel with some of those referrals and cases, which is good. But I won't go into all those details now. I'm trying to think if I left anything. Go ahead about neglect. So a parent taking a child with them to commit a crime, like the mom and son duo that decided to go burn her boyfriend's house down, that's not a good thing. If you're going to commit a crime, don't involve your kids. If you're doing a drug deal, don't bring the baby along in the car. Lots of other things that are really challenging when parents are exposing their children to activities and behavior that pose a danger. Children that are living in a home where the parents are using methamphetamine, other drugs in their presence. Again, I don't know what happened in 2000, but a lot of stuff changed then. Prior to 2000, Child Protection didn't get involved in anything related to marijuana. Nothing. If you had it, oh well, you might get a citation from the police, but Child Protection never got involved in that. Unless you got caught in some kind of big bust because you were the dealer. Otherwise, parental use, we didn't get involved in that. If you used through your pregnancy, we didn't get involved in those. 2000, boom, we're involved in those, just like we are with methamphetamine and so on and so forth. I will say that over the 33 years, and I've been reading police reports, right, regarding domestics, and we all know how enhancing alcohol is to everybody's attitude and behavior. I will say that not one time did I read a domestic where either party had just smoked weed. That was never an allegation. It's always something else, but that is not the common theme. So, Child Protection gets involved anytime a baby or mom at the time of delivery tests positive for those controlled substances. And we're trying to do better work around that because obviously we know addiction's a disease. And so our approaches are evolving into being much more compassionate, much more supportive, and less punishing. Okay? You can go ahead. Well, sexual abuse. When I began practicing social work a million years ago, if a kid showed up to preschool and tried to kiss someone else's private parts, you were very suspicious that kid had been abused or exposed to some kind of sexual activity, because children simply didn't have that knowledge. They weren't exposed to it. People had to go out of their way to get porn. You had to get in your car, go down, buy the magazine, rent the movie, have the stuff delivered to you in a paper bag or whatever. That's what you had to do. Nowadays, any child, pick up a phone, they say penis, they're 3 years old, boom, they got porn. We get cases from law enforcement that has been sent through the Internet Crimes Against Children, ICAC. They notify the BCA. The BCA notifies local law enforcement. Law enforcement sends me a report that says that little Cynthia, 8 years old, on the bus with her iPad or her smartphone, taking pictures of her private parts and that of her friend, and they're posting it on whatever it is it gets posted on. Child porn. We don't have any idea what happened. Unfortunately, kids know so much more about technology than a lot of us adults, and certainly people my age. And think of our families where English isn't the first language. The children are much more proficient at that. They have no idea that the children are exploiting themselves, basically. They just don't know. So that's obviously not a child protection case. My point is it's much more difficult for us to try to work with these types of situations where children are acting out sexually. Children, just like adults, we're constantly bombarded now with sexually explicit information and terms and sounds and everything. And kids are just as interested in that as adults can be. And so maybe they're seeking it out. Maybe they're accidentally being exposed to it. Maybe it's a family where they have co-sleeping, they practice co-sleeping, and so they're being exposed to it because the parents might think they're sleeping and they're not. Or it might be the situation where dad sits down, puts his daughter on his lap, and turns on the pornography and so on. So the child is reenacting that then at school. Or children simply making statements. They might say, my Uncle Jojo, who lives with me, touched my nasty. I don't know what nasty is. I mean, I can guess, but as I said earlier, we don't want to guess. So I'm not going to suggest what I think nasty is. I'm going to ask that child, can you point to your nasty? Maybe she's going to say here, I don't know. But we have to do a better job in trying to find out how do kids know what they know and what exactly are they talking about. A kid might say, you know, first grade, a family member made them have sex. I mean, is that kissing? Is that what they mean sex is? I don't know. Or do they mean physical touching of their private parts or penetration or something? I'm not going to spend too much time on this. I'm not going to gross you out any more than I already have. But this particular type of child abuse is so damaging. It's the kind of situation that keeps giving and giving and giving and giving generation after generation. So the sooner that we can intervene and get off that path of abusing children in that way, the healthier families are going to be, right? Okay. Domestic violence, this is another area that they greatly expanded. It used to be that we would only become involved if children were injured in the course of a domestic. Now we'll get involved if the perpetrator, again, holds them against their will, if there's a weapon used, if there's a sexual assault, if the victim of the violence requires emergency medical care. And I will say that it's a requirement in the state of Minnesota that anytime law enforcement responds to a domestic in which there was a report of some kind of physical assault or contact, that victim is offered a medical evaluation. That is protocol. I'm not talking about the protocol offering of a medical. I'm talking about my jaw is shattered, I have to get it wired together or whatever. We also get involved in domestics where the perpetrator threatens to kill a loved one, and that includes pets. So kids coming to school saying, you know, my dad killed my dog because my mom wanted to leave, or whatever the case may be. We take those cases. When children intervene, they're physically intervening in domestics. We get involved. We appreciate more consultation around domestics. And we probably get, and I'm just really guessing, but we probably get 15 or 20 reports a year where one partner has murdered the other and the children are present and so on. So we want to do what we can to prevent that, because that's not, in those homicidal situations, it's rarely the first incident. There's a slow buildup, and anybody who works in domestic violence, there are very specific signs and so on to be able to get involved much earlier than we're doing right now. Go ahead. I want to see if I forgot anything else. So say for instance we do get involved and we assist the victim in getting an order for protection and so on and so forth, and then we get another report sometime later while that order for protection is still in effect, especially when that order for protection includes the minor children. So it'll be an order for protection on behalf of self and minor children. If that victim violates that and allows the offender back into the home, exposing the children to further danger, sometimes child protection reopens a case before a new event occurs as a prevention. Go ahead. I think I said all those. Okay, go ahead. So when we're, you can go to the next one. When we're conducting our assessment, we're using a number of safety assessment tools. The role of child protection is to investigate a specific allegation of abuse. That's what our job is. So we're like the detectives for child protection. Obviously, the goal is to prevent repeat incidences of harm to children or recidivism. But it's really, we're an investigative body. So one of the things, or one of the tools that we use is called Signs of Safety. You can go ahead. And so this is a tool that very early on does a much better job of incorporating family and kin and community, whether it's religious, maybe not even identified by the family, but willing community members who are willing to step up and offer to be some support to that family and those children to avoid coming back to child protection. Because we all know life is so tough, especially right now. And we have good days, we have bad days, but for so many of our families, it's just one bad day after the other. And we want to do what we can to prevent those days from getting so bad that it circles back through child protection. So if we can build in a support network that is really meaningful and really connected and they know about each other, next time mom feels like she is going to go out and use meth and that's all there is to it, she can call a designated person to come and look after her children, and she's going to go do what she wants to do. Or if it looked like they're going to go down this other path, the family can put together a way to divert that from child protection. Much more natural, much more organic, and keeps children safe but still in a more natural system. Okay. You can go again. And then here's the number, answered 24 hours a day, 7 days a week. You can call us anytime, and we're happy to help. We'd much rather have you call us. What I don't want to hear is getting a call from someone and saying, oh, you know, I just didn't know if I should call, and so I thought about it for, you know, a long period of time, and maybe it was a child with an injury and it was 2 weeks ago and now no injury. Please call us at that time. Thank you for your time and thank you for your work.